Hi, my name is Ben Humphreys, and I'm an attorney in Elizabethtown, Kentucky, and I practice law with my good friend and law partner, Lewis Graham. And I'm going to talk to you today about estate planning. That's what we do at our practice. That's what we focus on. And today we're going to talk about the question that a lot of our clients have is, do I need a will or a trust? And to answer that question, you first have to figure out how you own your assets. And there's a lot of things that go into that, to answering that question. And so today we're going to focus on ownership of assets and how you own those things, legal ownership, and how that impacts your estate plan. Because that's a question that you've got to focus on, and you have to know the answers to those questions anytime you're doing your estate planning. And so most people that are married own their assets jointly and in survivorship. And what that means is, if you own a car with your spouse jointly and in survivorship, that upon your death, it will go directly to the person you own the car with. And so it's not going to go through your will, it's not going to go through your trust, regardless of which one you have. It'll go right to that other person. And so a lot of people that are married own their cars, their bank accounts, and their houses all jointly with their spouse. And so a lot of people in the past have gotten those wills that say, all to my spouse when I die, but if my spouse dies before me, then in equal shares to my children. And so you have to understand that will is not going to protect your kids, because if you die first, then all the assets that you held directly or jointly with your spouse pass directly to your spouse. They become your spouse's, they're solely owned by your spouse. And so the asset is no longer going to be controlled by your will or trust. And so even though your will or trust said that you wanted your stuff to go to your kids, if you die first, it's all going to be owned by your spouse if it's held jointly and in survivorship. And then that spouse's will or that spouse's trust is actually going to be the will or trust that controls where those assets go upon that spouse's death. And so that brings up a lot of questions, possibly about remarriage, or maybe your spouse wants different beneficiaries than you. And so anytime you're looking at estate planning, you have to understand, do I own something jointly and in survivorship? And if so, that means that asset is not going to pass through your will or trust. So it's important to understand that principle when you're doing estate planning. The other way that people own assets is they have a named beneficiary on the account. So a lot of people have a life insurance policy or an annuity or an IRA or 401k. And a lot of people have named beneficiaries on those accounts. And so when you die, if you've got a named beneficiary, it acts very similar in the manner that a jointly held asset acts, and that the asset goes directly to the person that you've named as a beneficiary on that account. And so again, if your will left everything to your son Tom, but you have somebody else as a named beneficiary on the account, your will doesn't control the asset. Then the person that you've named as a beneficiary actually controls where that asset goes. And so we've had a lot of people come in and say, well, I've left everything in equal shares to my kids, but I only had one kid as a payable on death beneficiary on my account. And what they don't understand is that upon their death, that asset that they had a named beneficiary on just to that one child is going to get the whole asset, and they do not have to legally share that asset with their brothers and sisters. And so that could really cause your estate plan to not be carried out in the manner that you want it to be carried out. It could be a potential threat to your estate plan. Another way that people own assets is they might have a trust, have an account that's being held in trust for a minor child. You could put money aside for a minor child until that child hits 18. And upon that child turning 18, that child will then become the owner of that account. And again, you have to understand that upon your death, that account is now linked or tied to that one child. So it's probably not going to pass through your will or your trust. And so now we've talked about joint assets not going through your will or trust if they're held jointly. We've talked about assets that have named beneficiaries on them, that those assets also won't go through your will or trust if you have a named beneficiary on them. And also assets that are held in trust for a minor child. And so the last type of ownership that you can have, the last type of legal ownership that they call it, is assets that you own just in your name, okay? So it's only the assets that you own just in your name that will pass through your will or your trust. And so a lot of people don't understand that, and they're a little bit confused by it. But it's an important point whenever you're doing estate planning to make sure that you understand that only those assets owned just in your name pass through your will or your trust. So, and kind of in review, if I own my car jointly with my wife, jointly with survivorship with my wife, that car upon my death is passing directly to my wife, even if in my will I left that car to somebody else. And so also if I've got my IRA, let's say I've got my IRA, I've got 5 kids, and let's say I want my IRA to go to all my 5 kids, but I only put one child on my IRA as a beneficiary. Upon my death, that IRA is only going to that one child. It's not going to go to all 5 of my kids, even if my will says it's supposed to. And so, and what about if I own a truck just in my name? A truck just in my name, my name is the only name on the title of the truck. Where would that asset go? That asset is the only asset that I own just in my name, and so it would actually pass through my will or my trust. And so this is an important point that if you're wanting to make sure that your children actually receive assets when both you and your spouse die, you have to consider how the assets are held whenever you're doing your estate planning. And so that's why whenever we do estate planning, we reach out to your financial planners and we make sure that they're working in coordination with us, and we make sure we know who your named beneficiaries are on all your accounts. And we do all that we can to ensure that your estate plan matches how you hold your assets, how you've got named beneficiaries on them. So I hope that's helpful to you, and I hope you have a great